Hiya, yeah, my name is Dr. Lewney, that is my real name. If you're born with a surname like mine, you've got to do a PhD, really. It's rude not to. So I did a PhD in guitar acoustics in the physics department down the road, would you believe? Then I joined the IPO, I became a patent examiner. I specialise in telecoms. So I'm just going to give you some basics of the patent application process, really. I'm not going to talk much about what you do with it after grant. I'm hoping John and Robert might help us out with the more of the real-world application of these things. I should say it's kind of nice to talk to an audience who actually knows a bit about what intellectual property is. You know, tell people at a party that I work in the intellectual property office, they think I'm some kind of weird estate agent for elves or something. So I'll just give you some basics and try and scoop through it a bit and leave a bit more time for questions. I think that's probably the best way of doing this. So, a patent is a 20-year monopoly, okay? It's granted in return for kind of open, honest disclosure. The word patent comes from the Latin for open. It rewards innovation and research and tries to discourage the kind of espionage, industrial espionage, and kind of rather unpleasant working practices that might exist if the only way to make money out of your idea was to keep it secret. That's not to do with trade. That's not to say that trade secrets have no place. Clearly, secrecy is beneficial in some respects, and it's kind of a difficult balance to make sometimes with that. So. I'll just talk about patents a little. In order to patent something, you've got to fulfill 4 criteria. I'll say something about each of these, but it's this third one here that really shouts out what kind of thing can be patented and what can't. It's got to have an industrial application. At a stroke, that gets rid of a whole load of ideas from patentability, most particularly kind of artistic and creative ideas. That's more properly covered by copyright. This little clause also gives us a bit of a shortcut when dealing with applications for perpetual motion machines. These things that violate the laws of physics. We just say it's not industrially applicable, so come back when you got your Nobel Prize. First thing it's got to be new. It's got to be novel. Never been done before. Not just never patented before, but never been publicly done before. So we ask, is it already part of the state of the art? That's everything that's publicly been done before. If we can find it in the art, the prior art, we say it's anticipated. So the state of the art is everything that's been publicly been done. And of course, a particularly fruitful source of citations is the applicant's own publications. The first rule of patents is like the first rule of Fight Club. You do not talk about your invention, at least not with anyone who hasn't promised to keep it secret, until you tell us about it first. So we're forever citing things like conference papers given the week before they applied, or marketing literature. It can be even just like emails to the wrong people. You've got to be very careful who you tell before you apply to us. Now, just because you tell someone, say in the pub or in a restaurant, it doesn't automatically mean that you don't get your patent. You're just giving someone else the opportunity to spoil your day later. Now, they probably won't. They probably will act as though they've signed a confidentiality agreement. They just don't tell us about it. But, you know, if you fell out with them or something, all it would take would be an email at a later date during what's called third-party observations, pointing out that you disclosed your invention. They could ruin your day. So just be aware of that. So I've told you what not to do, which is disclose your invention before you tell us. How exactly do you tell us? Well, you file an application, okay, with all these various bits. Don't pay too much attention to this. This is just kind of how it looks like on our system. And you've got to provide as much detail as you can right at the very start. You're not allowed to add stuff later, because that would really confuse all the dates about when precisely such a thing was invented. These dates are really important to the entire patent system. So you've got to try and put in as much detail as you can. The most important part of your application are things called the claims. Now, this is a hugely complicated telecoms claim. Don't worry about reading it too closely. But what a claim is, it's kind of like a paragraph written in very technical legal language, which sets out exactly what it is that you're doing that hasn't been done before. Now, we do get applications where the claim is, this thing's great, or sort of some alternative to that. It might well be great, but that's not like the kind of claim we're talking about. A claim in this sense is a very legal entity which sets out the monopoly that you seek. And the process of getting these claims in order it's kind of tricky. It's a bit like a property dispute in your garden, where what you will do, you'll try and claim your invention quite broadly. Okay, you want as big as a monopoly as you can. We'll look at that claim, and we're kind of professional pedants. We say, well, I could describe this thing that I've found, as though the fences of your claim stray onto other people's property. So we try and get you to narrow the language of your claim. But you don't want to narrow it so much that it leaves a little corridor for your competitor to scoot through. So making these claims, this legal language, is actually quite tricky. A little example here is this corkscrew. Now, you might look at this corkscrew and go, how exactly would I claim this? What would I really seek to monopolize about this corkscrew? So you might say, well, the point of this corkscrew is you grab the bottle like that, pull it like that, and pull it out. You might want to claim it like that. We'd say, well, that's not really what's called an enabling disclosure. All you're doing is you're trying to claim it by the result you want to achieve. You're not telling us the specific technical details of how it would achieve that. So then you might go, okay, I'll try and claim it where I've got two lateral handles and a kind of vertically oriented handle as well. If you did that, again, you'd be kind of missing the point of this thing. The real key to this invention isn't really the handles or anything, it's actually the shape of the screw. The shape of the screw is such that it follows itself in to the cork. If you tried it with a normal corkscrew, you'd just end up pushing the cork into the bottle. So the precise shape of the screw is the key to this invention. All the rest of the stuff just kind of exploits that particular component. So you've got to ask yourself what the precise component of your invention is that will give you the most useful monopoly. So when you're putting your claims together, you can do it yourself, such that it costs 230 quid if you apply as a private applicant. But these difficulties in getting the legal language together and finding out exactly what the key to your invention is, you might well be advised to use a professional patent attorney. Either hire them yourself or go via a technology transfer group or an innovation support group who often employ them permanently. These people are very skilled at this linguistic fence building. Now, are there any attorneys here? Any agents here? Got a couple of them here. The price is for a general average case, something like 3,000 to 5,000. Would you say? Is that about right? Just as an average case. More simpler cases would be cheaper. More complex cases more expensive. But that's kind of a ballpark figure, I think. That is just for UK coverage, by the way. If you want to make your coverage Europe-wide, first of all, you've got to get the thing translated into at least French and German. That's expensive with this technical language. And then the accumulation of all the fees throughout Europe, that starts pushing it to 10 grand or over. If you want full worldwide coverage, you might be talking about 50,000 or something. So this is a big business decision that you have to make, looking at the costs and benefits of how wide you want your coverage to be. So let's say you filed your application. By the way, it's cheaper and better for us if you do that electronically, by the way. It means we can see everything happening as it comes in. A lot of companies still fax things to us, so we've got to go down to the fax machine. Just try and do it electronically if you can. There's guidance on our website to show you how to do that. And then in September, we'll also be launching something called Ipsum, which is a new electronic service which will allow you to see all of the patent documents online. You'll be able to follow the case online pretty transparently and clearly. We're hoping that will be kind of useful. So then within 3 months of being asked, we'll do a search. First of all, we'll devise a kind of search strategy. Again, don't worry about this. This is our internal, this is kind of just our little crib sheet for ourselves where we devise a kind of strategy and then see how we might employ that strategy. One of the first things we asked ourselves at this point, as soon as we receive the case, because it might make a whole load of other work redundant, is it patentable in the first place? Not is it novel or inventive, the search will kind of tell us that, but is it excluded from patentability? Section 1.2 of the Act says various excluded categories. You can't patent a scientific discovery or mathematical method, because that would limit research too much, it was thought. If Einstein had never been able to carry on the work of James Clerk Maxwell, he might ironically never have left the Swiss Patent Office, where he referred to himself as a respectable federal ink pisser. Nice. You can't patent a literary, dramatic, musical, artistic work. Again, that's more copyright, which you receive automatically when you fix the expression of that work. You can't copyright a general idea in the same way as you can with patents, only the fixed expressions of those ideas. Just moving down a bit further, a presentation of information, you've got to divorce your invention from just the information it's going to show. Use the technical language which is independent of that information. That's where a lot of website applications sometimes fall down. Then section 1.3 says you're not allowed to patent anything that's contrary to public policy or morality. Your ears pricked up there, didn't they? So, actually, kind of smuttiness isn't generally an issue here. I used to share an office with a guy who did medical apparatus, including what was euphemistically called massage aids. So he had to disappear to the secure computer upstairs to look at these really quite dodgy websites. And just a standalone unit with a left-handed mouse. And, yeah. The only thing that tends to fall foul of this are things where there's a specific statute. Things like landmines or whaling guns, where there's a specific law which says you're not allowed to have them. Some biotech things fall foul of it as well. Have anyone heard of the Onca mouse? It's a transgenic mouse invented by Harvard University, which is susceptible to tumours. They tried to claim it as a rodent, and the court said, well, if you claim it as a rodent, you might start doing experiments on prairie dogs and capybaras and beavers and things. So you can have a mouse, but you can't have a rodent. And they cited 1.13 there, public morality. But the main source of these things is 1.2c, method for performing a mental act, playing a game or doing business, or a program for a computer. I've talked about presentation of information. Methods of doing business, it's anything where there's any kind of transaction going on. That case I showed you before, that it was a case where they wanted you to kind of buy programs by watching adverts. Even though there was no financial element to it, I thought that was kind of a business transaction where you're using your time in order to subscribe to the next program. So that's why I objected to on that one. But of course the biggest source is computer programs. Now of course a computer is a kind of reconfigurable machine, isn't it? And you shouldn't be stopped from patenting new machines. So it's obviously going to be tricky to decide what kind of computer programs are patentable and what aren't. Yeah, there's a 4-step test for this. This came about in a case called Eretel-McCrossan, which was about telephone exchanges. Civil servants like their 4-step tests. If you ever go on a date with a civil servant, don't be surprised if they're actually doing a 4-step test on you to see whether you're in order. But the 4-step test, the upshot of it is basically, is this computer program doing something to the real world, or is it just calculating and displaying something? In telecoms, a computer program will often either optimize the signal or encrypt the signal, but as long as it's still doing something to a real signal, a real input and output, that's generally okay. A computer program which runs a control system, it's actually controlling the real thing, that's generally okay as well. But if it is just calculating and storing things or displaying things, that might well fall foul of being a computer program per se, just a computer program on its own, which might well be excluded. So having read through the claims, we'll get it together, get our search strategy together. We'll use ECLA classifications to look at the very specific area of technology that you're looking at. We'll come up with a search results. This is what our system looks like. We use Epoch, which is run at huge cost and therefore great cost to us by the European Patent Office. So you can see I'm just putting a few little keywords in, or just combinations of words within the same sentence, and then kind of putting them together to give us a load of search results, which I'll look through. I tend to look through a few hundred documents, really. We put them in the viewer, and we use different coloured pens to pick out keywords. A lot of technology, you can actually just use the pictures. You just kind of play snap with the pictures. More technical subject matter, you've really got to use your keywords to try and look at these things, because the pictures don't really help much. So we'll get our search results together. We'll tell you what we think are the most important and most relevant documents that you should consider. We've also got to look at something called inventive step. You're not only just not allowed to do stuff that's been done before, you're not allowed to patent something that's obvious based on what's been done before. In order to work out whether something's obvious or not, we become a fictional person, okay? We become the person skilled in the art. This is a person who knows an awful lot about the technology you're talking about, but crucially hasn't got an inventive bone in their body. It's like an imaginary person with no imagination, okay? A judge once called him a nerd or a team of nerds. And funnily enough, civil servants don't seem to have much trouble becoming this person in the course of their day. So this 4-step test was set out in these two cases. Again, the upshot of it is it's a way for us to try as objectively as we can decide whether something's obvious or not without any use of hindsight. Obviously, in hindsight, you'd be able to go, oh, well, of course you would have done that. You've got to try and get rid of that hindsight in making these kinds of judgments. So that's basically it for the process. For the applications process, we're currently trying to make sure that patents are granted within 4 years. We're having some success with that. Or you can ask for it to be accelerated if you've got good reason. And then in your 5th year, you'll start paying to uphold the patent. Renewal fees. So it's 70 quid in the 5th year, up to 600 quid in the 20th year. That's a total of 4,500. Again, you've got to ask yourself whether the costs and benefits to keeping it going are there. But of course, the biggest cost of a patent after grant would come if you had to actually enforce it in court. You could be talking upwards of $250,000 for that. I think that's just the way it is with civil law, really. It's not just patent law. That covers all kinds of intellectual property law, contract law, family law. Anything that isn't a criminal offence, it just seems to be, it is very expensive to prosecute, libel or slander or these kinds of things. We're trying to help out a bit with this, actually, with things called opinions. What they are, for 200 quid, a senior examiner will look at the case, say it's an infringement case where one party is claiming infringement on behalf of another one. A senior examiner will spend a couple of days looking at the case and trying to give his or her opinion on how that case might go if it actually went to court. Just try and get down to the real issues that would be the core of the court case. Now, obviously, it's non-binding, so the parties don't have to actually do what we tell them to do. But we are having some success with that. So it's only a fairly recent service, but already there are some examples of court proceedings being dropped by the person who the senior examiner thought would lose the case. They've kind of looked at the opinion, looked at the arguments about what they considered the key issues to be, and they've just dropped the case entirely. So that's kind of encouraging that. So I think that'll do for me, actually. I'll just leave loads of time for questions. So thanks very much.